Swayam Prabha. Digital India. Educated India.
Hello everyone, I am Dr. Kavita Solanki, Professor of Law at University School of Law and Legal Studies, Guru Govind Singh Indraprastha University, Delhi, Dwarka. We will talk about Labour and Industrial Law 1, and here I would be taking lecture number 10, which is on Payment of Bonus Act 1965. This act is, before passing of this act, there was no criteria, no uniformity into giving the bonus to the workers. So this act has been set up just to regulate the relation between the employer and the employee and to have the amicable relations between them and to give them the justified due which has to be given by the employer to their workmen. So when we talk about under this act is we are not having any statutory definition of the bonus. So this act basically contains 40 sections and the 4 schedule. In the event that you have performed really well, you may be eligible to get a bonus, which is an additional sum of money. The distribution of the profits accrued by the company to its workers and employees is the fundamental objective of the practice of offering bonus. The report of the bonus commission suggests that it is difficult to define in right term the concept of bonus, but it is possible to urge that once the profits exceeds a certain base, labor should legitimately have a share in them. A bonus is therefore a legislative requirement that an employer must fulfill. When we talk about some important cases, the case is Muir Mills Company versus Muir Mills Mazdoor Union, Kanpur, 1955. The Supreme Court has held that the bonus was neither gratuitous nor deferred payment of the wages, and where wages fell short of the living standard and the industry made profits, part of which was due to the contribution of the labor, a claim of bonus might be made legitimately by the workmen. So this is not the gratuitous amount and it is not the deferred payment, because if the someone is getting the the cost of living index is very low and it is not possible for the worker to maintain or sustain. So this is the duty of the employer, because the employee, they have given their contribution best. That's why this the employer, they could achieve a very good height, they are having good name, they could get the profit. So this is the legitimate duty of the employer to give something out of that profit to their workmen. In state of Tamil Nadu versus Subbanarayan Gum, AIR 1998, Bonus Act is a piece of welfare legislation enacted for the benefit of a large category of the workmen seeking a living wage to make their lives more meaningful, and it has been guaranteed by the Article 21 of the Constitution. So when we talk about bonus, it has to be treated like a living wage. When we talk about living wage, it has been defined in Article 43 of the Constitution. The purpose is to give the living wages, to give the luxurious life to the worker, or at least they can enjoy other benefits. Bonus may be the customary, it can be the customary bonus. Such bonus is not covered under the Bonus Act, and therefore it is payable over and above the bonus payable under this act. When we talk about applicability of this act is applicable to whole of India, and here under this act it is applicable. We are having the 2 type of establishments which has been given under this act is, one is the establishment in private sector and the other is in public sector. When we talk about establishments in private sector, that has been defined in section 2 clause 15 of this act is, and it means any establishments other than the establishment in public sector. When we talk about that is public sector, it has been defined in section 2 clause 16, and it means public sector establishment means an establishment owned, controlled or managed by a government company, a corporation in which not less than 40% of its capital is held, whether singly or taken together by the government. So, government has given the 40% of the minimum share into this, or the Reserve Bank of India or a cooperative owned by the government or the Reserve Bank of India, they would be coming under that establishment. Establishment on which this act is applicable, every factory and every other establishment in which 20 or more persons are employed on any day during any accounting year, any establishment or class of establishment as notified by the appropriate government employing such a number of persons less than 20 as may be specified into the notification, that the number of the persons so specified shall in no case be less than 10. So, this act is applicable upon the establishment if it is a case of the factory or where the number is, that is a 20. But sometime if the number is lesser than the 20, then in that case it is a duty of the appropriate government. They would be notifying into their official gazette. That is, this act would be applicable upon those establishments where the number is lesser than 20. An establishment to which this act applies shall continue to be governed by the act, notwithstanding that the number of the persons employed fall below the 20 or the number of specified into that notification. Sometime what happened, because this, when we talk about the applicability of this act is, the person would be eligible to get the bonus under this Payment of Bonus Act 1965. Those who are the number is that is for this establishment or the factory, the number should not to be lesser than the 20. But sometime what happened, at the time they had the 20 or more than 20 number, but later on when they feel so, now the number has been shrinked, now the number is 10, that number has been reduced. Now the question comes whether the employer would be liable to give the bonus to their employee. In that case, this is a duty of the employer is, once they have started the payment of this bonus, they have to continue it irrespective of the number. So, even the number has been reduced, so they would be continuing with the process of the bonus. And when we talk about establishment on which this act is not applicable, employees employed by the Life Insurance Corporation of India, seamen as defined in section 3 clause 42 of the Merchant Shipping, employees registered or listed under any scheme made under the Dock Workers Regulation of Employment Act 1948 and employed by registered or listed employers, employees employed by an establishment engaged in any industry carried on by or under the authority of the department of the central government or of the state government, or it can be the local authority. Employees employed by the Indian Red Cross Society or any other institution of a like nature, including its branches, university and the other educational institutions including hospitals, chambers of commerce and social welfare institutions established not for the purpose of profit. This act will not be applicable upon these, and employees employed through the contractor on building operations will not be applicable, Payment of Bonus Act. Employees employed by the Reserve Bank of India, again it will not be applicable. Employees employed by Industrial Finance Corporation of India, any financial corporation established under section 3 or any joint financial corporation established under section 3A of the State Financial Corporation Act 1951. The Deposit Insurance Corporation, the National Bank for Agriculture and Rural Development, the Unit Trust of India, the Industrial Development Bank of India. So, these are the establishments where this Payment of Bonus Act will not be applicable, and we are having more. So, the Small Industries Development Bank of India, established under section 3 of the Small Industries Development Bank of India Act 1989, the National Housing Bank. Any other financial institution other than a banking company being an establishment in public sector, which the central government may by notification in an official gazette specify having regard to its capital structure, its objective and the nature of its activities, the nature and the extent of financial assistance or any concession given to it by the government or any other relevant factor. employees employed by inland water transport establishments operating on routes passing through any other country, the payment of bonus act is not applicable upon these things, on these establishments. So we are having some important definitions. In section 2 clause 5, when we talk about the appropriate government, it means in relation to an establishment in respect of which the appropriate government under the Industrial Dispute Act 1947 is the central government, the appropriate government would be the central government. And where in relation to any other establishment, the government of the state in which that establishment is situated. So that would be any of the state government. So when we talk about this appropriate government, so sometime the central government can be the appropriate government if the matters comes under the Industrial Dispute Act 1947. So for this, the appropriate government would be the central government, but for the other matter, the state government would be the appropriate government. When we are talking about the award, it has been given in section 2 clause 7. It means an interim or the final determination of any industrial dispute or any question relating thereto by the Labour Court, Industrial Tribunal or National Tribunal constituted under the Industrial Dispute Act 1947 or by any other authority constituted under any corresponding law leading to the investigation and settlement of the industrial dispute in force in a state and includes an arbitration award made under section 10A of the act or under any law. So when we are talking about the award, so under the Industrial Dispute Act, we are having the Labour Court, we are having the tribunals, we are having the National Tribunal. So whatever the award, whatever the decision or the judgment has been given by these authority, the decision has been given by these authority would be coming under the definition of the award. But sometime if someone has been appointed in section 10A of the Industrial Dispute Act, that is for the purpose of the arbitration, so the decision or this award which has been given by the arbitrator, that would be considered to be the award for the purpose of this act. In section 2 clause 8, banking company. Banking company means, because this is very, very important for the purpose of this act, banking company has been defined in section 2.8. It means banking company is defined in section 5 of the Banking Companies Act 1949, and it includes State Bank of India, any subsidiary bank as defined in State Bank of India Act 1959, or it is defined here the first schedule of the banking companies. So all the list of the banking company, because into this act we are having the fourth schedule. So when we talk about the first schedule, it deals with the banking company. So and the banking company, they have been given under this schedule. So any corresponding or new bank constituted under section 3 of the Banking Company Acquisition and Transfer of Undertaking Act 1980, any cooperative bank which is defined in clause which is defined in section 2 of the Reserve Bank of India Act 1934, or any other banking institution which may not be notified in this behalf by the central government. Now the definition of the employee. So definition of the employee has been defined in section 2 clause 13. Any person employed on a salary or wage not exceeding 21,000 per month in any industry to do any skilled, unskilled, manual, supervisorial, managerial, administrative, technical, clerical, or for hire or reward, whether the terms of the employment, it can be the express or it can be implied. So apprentice will not be treated to be the employee. So when we are talking about the definition of the employee, almost the same definition has been taken here under the Payment of Bonus Act into when you talk about the other other acts. So the definition is, but with the, because the ceiling has been imposed, that is the employee should not draw the salary more than 21,000. The rest is almost same. So when we are talking about the cases, the case is Cooper Allen and Company Limited versus their workmen. Into this case, it has been held that the temporary workman is entitled to workman on the basis of the total number of working days worked by him. Because when we are talking about under this act, who would be eligible to get the bonus under this act is, the two conditions are very, very important. Number one is that this workman is getting the salary less than 21,000 and he has completed number of working days, that is a 30 days he has completed. So if the someone is doing the work, has completed the 30 working days, would be entitled to the to get the bonus under this act. Either the person is a temporary workman. Next is Automobile Karamchari Sangh versus Industrial Tribunal. So into this case, Allahabad High Court has held that a part-time employee like a sweeper engaged on a regular basis is entitled to the bonus. Canon India Limited versus Niranjan Das, it has been held by the court that a dismissed employee which has been reinstated back with back wages is entitled to the bonus. So when we are talking about, see, either someone had been dismissed, then in that case, and again after a time, this person had been reinstated back on a similar kind of the wages which had been given earlier. So he would be entitled to get the bonus under this act. Bank of Madurai Limited versus Bank of Madurai Employees Union. So into this case, it has been held that a retrenched employee is eligible to get the bonus provided that he has worked for a minimum qualified period. So if you are talking about the retrenched employee, because we have covered this retrenchment in detail in Industrial Dispute Act 1947. So when we are talking about the company, normally the practice is, if they want to retrench someone, the rule is that is the last can be retrenched. So last would be the first who would be retrenched in any of the industry. So if any person who had been retrenched, he would be entitled to get the bonus under this act. But with this condition is he has completed the 30 working days, because that is a mandate under this act. Malabar Tile Works versus Industrial Tribunal. Into this case, it has been held that piece rated worker is entitled to the bonus. So here we are giving the coverage to the piece worker employees. So we are having the piece worker is there into the any of the industry, because when we are talking about normally these people, they are doing the work on the basis of the piece. So normally the time is not important for them. So they would be getting their wages or the benefit once they would be completing their piece. So the piece rated workers would be entitled to get the bonus under this act. When we talk about section 2 clause 14, employer, so here employer includes in relation to an establishment which is a factory, the owner or the occupier of a factory, including the agent of such a owner or occupier, the legal representatives of the deceased owner or the occupier, and where a person has been named the manager of the factory under clause F of the subsection 1 of section 7 of the Factory Act 1948, the person so be named. So when we are talking about that is employer, so if it is a case of the factory, the owner or the occupier of the factory can be the employer, or the agent who had been assigned for this, they can be treated to be like an employer. And when we are talking about the manager under the Factory Act, would be treated like an employer. And in relation to any other establishments, the person who or the authority which has the ultimate control over the affairs of the establishments, and where the said affairs are entrusted to a manager, managing director or managing agent, such manager, managing director, so they would be coming under the definition of the employer. Now the next definition is that has been given in section 2 clause 21, which is very, very important, and that is the definition is salary or the wage. When we are talking about the salary or wage means all remuneration other than the remuneration in respect of overtime work capable of being expressed in terms of money, which would, if the terms of the employment expressed or implied were fulfilled, be payable to an employee in respect of his employment or the work done in such an employment, and includes DNS allowances, that is to say all cash payments by whatever name called, paid to an employee on account of a rise in the cost of living, but we are having the things which is not the part of it. So when we are talking about wages, wages means all the remuneration. So remuneration, the person is getting the remuneration normally when they finish their work, later on they are getting their remuneration. So but these remuneration or the wages, they must have to be expressed in terms of the money. And here we are including the cost of living index, because and we are talking about the dearness allowances. So these things, they would be considered under the definition of the wages. But the other allowances, we are having the other allowances which are not the part of the wages. So other allowances which the employee is for the time being entitled to, the value of any house accommodation or supply of light, water, medical attendant or other amenity, or any service, or of any concession supply of food grains or other articles. It will not be coming under the definition of the wages. Any travelling concession, any bonus including any incentive productions or the attendance bonus sometime the employer give, any contribution paid or payable by the employer to any pension fund or to provident fund or for the benefit of the employee under any law for the time being in force, any retrenchment compensation or the gratuity. So they won't be coming under the definition of the wages. So or other kind of the retirement benefit which is payable to the employee, or any kind of ex gratia payment made to the worker will not be coming under the definition of the wage. Any commission payable to employee is not the part of the wages. Section 2 clause 4, it talks about allocable surplus. So when we talk about allocable surplus, it means in relation to an employer being a company other than the banking company which has not made the arrangement prescribed under the Income Tax Act for the declaration and payment within India of the dividends payable out of its profit in accordance with the provision of section 194 of this act, 67% of the available surplus in the accounting year, and in other case 60% of the available surplus. So we would be taking the allocable surplus after some time. And when we talk about available surplus, which has been defined in section 2 clause C, it means available surplus under section 5 of the act. Now the question comes, who would be eligible for the bonus? So according to section 8 of this act, every employee shall be entitled to be paid by his employer in an accounting year bonus in accordance with the provision of this act, provided he has worked into the establishment not less than 30 working days in a year. This is the mandate, because who wants to get the benefit of the this bonus is he has to complete 30 working days in that accounting year. In a case, project manager, Ahmedabad project ONGC versus Shyam Kumar, 1995, it was decided that the employee suspended but subsequently reinstated with a full payback wages cannot be treated to be the ineligible for the bonus period of the suspension. The person would be disqualified for the bonus. So we are having the conditions for disqualification for bonus in section 9 of this act. An employee shall be disqualified from receiving bonus under this act if he is dismissed from service for fraud or for riotous or the violent behavior while on the premises of that establishments, or the person has committed theft or misappropriation or sabotage of any property of the establishment. So the person can be disqualified to get the bonus under this act is the person has done the fraud. So if the person is involved doing that kind of the act or doing that kind of the omission which comes under the category of the fraud, so giving false information, misleading the public, or not giving the proper information, if there is a duty to speak, not speaking at the time, so doing the fraud in that way. So and the second is, if the person is involved into violence, then in that case the person will not be allowed to get the compensation. Or if the person is making the sabotage of the property, making the theft of the property, and employer don't know anything because the employer is having the faith on that workman, so these things, if they found that the person is, this workman is involved, he is doing this kind of the illegal activities, he can be disqualified to get the bonus under this act. So we are having a case for this, Pandian Roadways Corporation Limited versus the Presiding Officer Labour Court. Into this case, the Madras High Court has held that right of the management to forfeit the bonus on the ground that the workman was dismissed from the service for misconduct and would be only with a reference to the accounting year in which the said act of the misconduct was committed, and not with a reference to any year or the years preceding or succeeding the accounting year in question. So, but the person would be ineligible to get the bonus, but he would be not entitled to get the bonus for that accounting year. If the character or the conduct of the person was good before doing this act into the previous years or into the subsequent years, he would be getting the bonus. Section 14 is dealing with how to compute working days. So, an employee shall be deemed to have worked in any establishment in any accounting year, also on a day on which he has been laid off under an agreement or as permitted by standing order under the Industrial Employment Standing Order Act 1946 or under the Industrial Dispute Act 1947 or under any law applicable to the establishment, or he has been on leave with a salary or wage, or he has been absent due to temporary disablement caused by the accident arising out of and in the course of the employment. The employee has been on a maternity leave with a salary or wage during the accounting year. So, these person, they would be entitled to get the compensation, because if the person has been, if any of the workmen has been laid off, then in that case, when we talk about the laid off, already we have discussed this point in Industrial Dispute Act 1947. So, there is no fault of this workman, because due to the shortage of the raw material, there is, if any kind of the machinery is not doing the work, but the person is available to the work and he is coming into the industry. So, the person had been laid off this kind of the reasons, or either it is a case of the Industrial Dispute Act, or sometime this kind of the terms and the condition has been expressly mentioned into the Standing Order Act. So, in that case, because if the things has been mentioned into the Standing Order Employment Act 1946, that is in case of the layoff, the person would be entitled to get the bonus. So, the person would be getting all these benefit, and he has been on a leave with the salary or the wage. If the person is on a leave, is getting the salary, then he is entitled to get the bonus. If he has been absent due to the temporary disablement caused by the accident which has been arising in the course of employment and out of course of employment, because when we are talking about this point of the disablement is, we are having the Employee Compensation Act 1923, into which the list has been given, because there the good explanation has been given, and we are having the schedule. Say when we talk about a total disablement, so the person would be not in a position to do the work which he could do it before the accident, and the loss of earning capacity becomes the 100. So when we are talking about that is this is the kind of the temporary disablement. If it is a case, then the loss of earning capacity would be lesser than the 100, and the list has been given. Say for example, when we talk about, if into the industry, if the person is amputation of one hand, so that is the injury has been indicated into that schedule, and in front of that the loss of earning capacity has been cited. If there is a loss of one thumb, there is a loss of a kind of small finger, index finger, so everything has been mentioned. So sometime we add multiple injury, and we check that like how much the percentage is a loss of earning capacity. So if the earning capacity is lesser than the 100, it means the person would be treated to be the temporary disabled. So due to this accident, the person was doing the work into the industry, but now the person has become, that is temporary disablement, due to the temporary disablement, and he was doing the work into the course of employment and out of course of employment. He was doing the work into the factory, or the person was going back to the home. So he would be entitled to get the bonus under this act. Or any employee who has been on a maternity leave with the salary or wage during this accounting year would be entitled to get the compensation, entitled to get the bonus. Next is minimum and the maximum bonus. So, this is very important. When we are talking about minimum bonus to employee for accounting year, it has been clearly mentioned that in section 10. When we are talking about the minimum bonus, that is, it has been mentioned into this Payment of Bonus Act, that is 8.33% has to be given. That is for that accounting year. And when we are talking about that is a maximum bonus, 20% maximum bonus can be given to any of the worker. It has been mentioned into the payment of, because the limit has been decided. So, this is because when we would be calculating the minimum bonus and the maximum bonus, so would be taken into the account of the minimum bonus and the maximum bonus. So, accordingly the salary would be adjusted. So, when we talk about this thing, minimum bonus can be 8.33% of the salary or the wage earned by the employee during this accounting year, or rupees 100, whichever is higher, whether or not the employer has any available surplus in the accounting year. So, we would be checking, that is, here we are not bothered like how much available surplus is there into this accounting year. When we are talking about the available surplus, so available surplus can be calculated if the person has to pay something. Say for example, he has to, this thing has been given into one of the schedule. So, the criteria has been given when we are talking about allocable surplus. So, if the person has to pay for kind of the whatever the due, the thing has to be depreciated from this allocable surplus from the gross profit, and from the gross profit we have to minus this the dues, either it is a tax or any kind of the dividends or the any kind of the dues. So, when we minus all these things and the income tax, so after making all these things, making the deduction, whatever the amount is with the employer, that would be titled as the allocable surplus. So, they would be giving this bonus from that amount. So, maximum bonus if allocable surplus is greater than the minimum bonus. So, it is binding duty of the employer to pay to every employee in that year in proportion to the salary or the wage earned by the employer during the accounting year, subject to the maximum of 20% of such a salary or the wage. And if there is no allocable surplus, so in the absence of any allocable surplus, the concerned accounting year, only the minimum bonus is payable. So, when we talk about minimum bonuses, because a minimum bonus can be given, has to be given in all the circumstances. Sometime employer is saying, I am already into the loss, because if they see their allocable surplus, they are not having something great. Then in that case, because this is the rule of the bonuses, once the bonus starts into any of the industry, it cannot be stopped. Might be the person is into the loss. Employer is saying, I am not in a position to pay the bonus, but this is the no justification. Into all the circumstances, the person has to give the bonus. But sometime, if the employer is having the good allocable surplus, so after making all these due deductions, and he is having that is out of this net profit, if the person is having the sufficient amount, and it can be indicated very clearly, that is now the person is, this employer is getting the profit of this accounting year. That is the duty of this employer, that is for that accounting year, he has to give the maximum bonus for that, and that is a 20%. So, we are having it has been held that in view of the settlement entered by the employer before the conciliation officer or paying bonus at a higher rate, the bonus was held accordingly payable for that year. Calculation of bonus with respect to certain employees. So, where the salary or the wage of the employee exceeds 7,000 rupees per month, the bonus payable to such employee under section 7, as the case may be under section 11, shall be calculated if his salary or the wage was 7,000 rupees per month. So into the industry, if the someone is getting the salary that is 7,000 or 8,000, it can be 10,000. So how the this kind of the what is the criteria, how we would be counting how much the wages how much the bonus has to be given. If the person is drawing the salary more than 7,000, it can be anything, but to calculate the bonus, only the 7,000 has to be taken into the consideration. So all the calculation would be done because they would be counting the 7,000 only. So on that basis, the salary would be or the bonus would be given to that person. When we talk about, because bonus has to pay even in case of the loss, and for this the principle of set on and set off has been given here under this act. So when we calculate the bonus, say if any of the workmen is getting the salary per month, that is 2,000. So how we would be calculating the bonuses? So if someone is getting the salary 2,000 per month, so we would be counting for a year. So 2,000 into 12, that would be 24,000. So into any industry, so when we calculate the bonus, the thing is, if someone is getting the salary, say for example, if someone is getting 2,000, okay, per month, so we must have to calculate the salary for the next 12 months. So that would be 24, that is 1,000. So for which we can decide the minimum bonus and the maximum bonus. So this amount here, it has to be, we must have to see in that way, that is 8.33. So whatever the amount would be, that would be, say if we are doing in that way, so amount would be 19,000, that is 19,9920. So this is the amount. So after making the calculation, so it means or amount is 100. So this is the criteria when we are talking about, that is how the minimum bonus can be given it to any of the worker. And but when we are talking about, because this is a rule for the minimum bonus. But if someone is getting the salary 10,000 per month, so accordingly that is 10,000 per month would be, that would be, accordingly we will decide that is 10,000, because that was in case of the 2,000, but here it's 10,000. So in that way we can count, that would be, 1,20,000, and that would be amount. And because we are going for the minimum bonus, so that is 8.33. So this would be the amount. But just to because here why we are making this calculation is, here we are saying this amount like 10,000 has to be treated the 7,000. So to decide this bonus, we cannot take the 10,000 into the account. So only for the minimum bonus, the amount all the time would be considered, that is 7,000. It will be counted like person is the person is even 15,000, the person is withdrawing the salary, but we cannot give the bonus on that basis. The criteria would be on the basis of the 7,000 we would be giving the bonus. So when we talk about computation of the bonus, so some steps are very important to compute the bonuses, because computation of gross profit, and how much the gross profit is there, we must have to take the account of it. After that, some deductible from the gross profit. So whatever the due is there, say for example the income tax or any kind of dividend or other kind of the responsibility on the employer. So they would be giving first their outstanding outstanding things, they would be settled first, and after that whatever the available surplus would be, accordingly they would be deciding, okay, now this is the available surplus, this is the total how much money they are having now. So they would be doing in that way. And so bonus keeping into the consideration of the maximum and the minimum limit. And because when we talk about that is because normally for the computation of the gross profit in case of the banking company can be calculated in a manner which has been given into the first schedule. So when we talk about the first schedule is here, that is they have given, that is the banking company, and for the banking company, that is the 60% available surplus can be taken into the account. But when we, because that has been mentioned into your schedule 1, but when we are talking about schedule 2, here that is non-banking companies we are having, and here the employer can give that is a 67% for this. So for the banking company, the balanced amount after giving the dues, if that is so they can give out of this dues. And for the banking company, the 60% has to be taken into the account, and for the other is 67% has to be taken into the account. So this is the we would be saying like they must have to follow this thing. After that, in section 6, sums deductible from the gross profit. So depreciation admissible under section 32 of the Income Tax Act. So what can be deducted? So we were talking about the second point, into which we are saying that is these kind of the things has to be deducted. So we are having the long list for this. So for making the deduction from the gross profit, that depreciation which has been given in section 32 of the income tax has to be made. Development rebate or the investment allowances or the development allowances which the employer is entitled to deduct from the income under the Income Tax Act 1961. Any direct tax payable for the accounting year by the employer has to be deducted, and such other sums as specified into the third schedule. So and the company which are the other than the banking companies, so they would be making the deductions. So into which if it is a case of the other company, this is other than the banking company, so they would be making the deduction for dividends payable on a preference share capital. 8.5% of the paid equity share they have to making the deduction for this for the accounting year. And for the foreign company, 8.5%. If it is a case of the foreign company, 8.5% on the aggregate of the value of the net fixed asset and the current asset of the company in India after deducting the amount of its current liability in India. And so when we are talking about banking companies, so the following things can be deductible. Dividends payable on a preference share capital, 7.5% of the paid up equity share capital as the commencement of the accounting year. So these are the heads has been given. So they would be taking care of like they would be making the deduction, and later on they would be the bonus would be given once they would be having their that is allocable surplus, or because that can be allocable, and they will check that how much available surplus is there. So after making these making the deductions, so we would be taking the note of it. And for the foreign company, the following are the deductible dividends, all these things. And we are having the corporations even. So for the in case of the corporations, the following things can be deducted. They if it is a case of the corporation, so they would be making the deductions for these heads has been given. So 8.4% of its paid up capital and 6% of its reserve, and they would be showing this thing into their balance sheet at the commencement of the accounting year. So in case of the cooperative society, they must have to take care of these points for the deduction, like 8.5% of the capital invested by such society into its establishment. Such sum as has been carried forward to a reserve bank fund under the relating to the cooperative society or any other employer not falling under the aforesaid category. So the following are the deductible: 8%, 8.5% of the capital which invested at the commencement of the accounting year, it has to be deducted. So when we are talking about computation of the available surplus, so available surplus shall be, it can be the aggregate of gross profit of the accounting year after deducting the sum. So now after making the deductions, whatever this gross profit is having, that would be the that would be the available surplus. So now we are having this had gross profit. So this is an amount equal to the difference between the direct tax calculated under section 7 in respect of the amount equal to gross profit of the employee for the immediately preceding accounting year. And so we are having these kind of the provisions which have to be taken care of. When we are talking about computation of allocable plus, so this was the case of the available surplus, because the available surplus means after making the due deductions, whatever the amount the employer is having, that is, we would be saying this is a gross profit. And so, but when we talk about computation of the allocable surplus, so 67% of the 60% of the available surplus as the case may be, because the scheme for providing the minimum and the maximum bonus is based upon the device of set off and the set off of the allocable surplus of a particular year. Because when we would be talking about, that is, if we are talking about minimum bonus or we are talking about the maximum bonus, so how we would be deciding whether the minimum bonus can be given, whether this kind of the company can they afford to give the minimum bonus, or whether they are in a position to pay them the minimum bonus or not. So it is based upon the principle of set on and the set off, and which is for this allocable surplus of a particular year. Because when we talk about this amount of set on and set off has to be taken into the this amount for the payment of the bonus with the allocable surplus, and this available allocable surplus for the relevant accounting year has to be arrived after taking into the account of the figures of the set on and the set off in the previous year. So basically when we are talking about this the principle of set off and the set off of the allocable surplus, it has been mentioned into section 15. So because this is very very important when we talk about this allocable surplus. So when we are talking about this this allocable surplus, so just understand it better. When we talk about this allocable, if our allocable surplus is exceeding the amount of the minimum bonus, or if the allocable surplus is exceeding the maximum bonus, so we are having the principal provision of the set on and the set off. So like we can take it with the example of this. Say if someone is having the salary that is 12,50,000 for a year. So when we talk about that is a minimum bonus would be, we can count the minimum bonus for this 8.33% and the maximum bonus would be 20%. So we are counting the salary that is for a year, that is 12 lakhs 50,000, so for example, if it is a salary, and for a year. So and we have to see that is a minimum bonus, and if we are talking about the maximum bonus, so for this minimum would be 8.33, right, and the maximum would be the 20%. So how we can do that? That is, if we are talking about the minimum bonus for this would be, that would be that would be minimum bonus. And so 1,04,167 would be minimum bonus, and maximum, if we are talking about 20%, that would be 25 lakh would be maximum bonus in that case. So the rule would be, if allocable surplus is more than the maximum bonus, then so subject to 20% of the salary. Say for example, if they are having, that is they are having, allocable surplus is more than the maximum bonus, because maximum bonus is this much, 25 lakhs. But if the employer is having this allocable surplus is more than this 25,000, it means they are with a good amount, then in that case what they can do, that is what they would be doing, they would be keeping the share for this for the next accounting year. So they can give the 20% of the salary, and we would be saying that is a set on principle. So they are set, and that's why they are owned, that's why they are giving this much of percent. So there is no problem, because already they are having good profit, so they can give the maximum bonus for this. So when they can give the better bonus, that would be the set on. But sometime, and they can give this good bonus for the next 4 years, because now they are having this allocable surplus is more than the maximum bonus, because this is the maximum bonus, but they are having more amount with them, then in that case they can give the this much of maximum bonus. So we would be saying that is this is the set on principle. But sometime, that's why they can afford it to give it for the next 4 years in that case. But if the allocable surplus is less than the minimum bonus, so now, because now already the employer is in a loss, he cannot give this minimum bonus now. So for this, that is, we would be saying this is a set off. Set off means like this kind of the deficiency, if the person is not having this much of amount, so this kind of the deficiency can be carried forward. So he can manage this thing for they can carry forward this kind of the deficiency, but they have to give the bonus to their employees. So this is that's why we can count in that way, and we are having the schedule for this. When we talk about into one of the case, it has been mentioned that what should be done in case of the misconduct of an employee causing financial loss to the employer. The employer can deduct any of the loss for the bonus payable under this act, and for that accounting year only. So the minor misconduct causing the financial loss to the employer, so then in that case they have to see the gravity of the of their misconduct, and on that basis. Now the time limit for paying the bonus, section 19 is talking about amount payable to the employee by way of the bonus shall be paid in cash by the employer. The time limit is, if there is any dispute regarding the payment of the bonus pending before any authority, then within a month on which the award become enforceable or the settlement come into operation in respect of such a dispute. And in other cases, if the matter is pending, then in that case before the authority, then within a month once the award would be enforceable. And in other cases, within a period of 8 months, if any kind of the industry has been closed, then the person would be giving the bonus for within 8 months of that accounting year. Extension of the time for the payment of the bonus, whether it can be extended. Yes, if the appropriate government or any authority or the appropriate government, they specify if they are okay upon the application which has been made by the employer, and they are having the sufficient reason for it, and so by the order they can extend the set period of this 8 months, and for further period as they think fit. So however that total period so extended, it shall not be in any case exceed the 2 years. So the maximum, that is a time limit is, that is they cannot go beyond 2 years. So recovery of the bonus due from the employer, application to the appropriate government, because if someone wants to recover the bonus which was due from the employer in section 21. So application can be made by the employer himself or any other person who has been authorized by him in writing. And in case of the death of the employee and his assignee or the legal heirs, they may make an application to the appropriate government for the recovery of the money due to him. So the time limit for the making the application is the appropriate government has to be satisfied, and if they are satisfied, they can entertain that period. And so on that basis, they can issue this certificate to collect upon the satisfaction. Once the government would be satisfied, then they would be issuing a certificate to the collector, that is this kind of the amount which has been due to be given. So we are having the thing, so reference can be, if the reference has been made, so then in that case, so reference can be given to the industrial dispute under the Industrial Dispute Act to settlement or this kind of the problems. So they can make the investigation and settle the industrial dispute accordingly. And so presumption about the accuracy of the balance sheet is there, because from the balance sheet the things they can understand that. And audited accounts of the banking company not to be questioned, because they have to maintain their accounts properly. And obligation of the employer under section 26, because the employer has to be ready with to maintain the register records and the other kind of the documents in such a form which has been prescribed. And maintenance of the registers, this is the duty of the employees. They must have to register, into the register they must have to show the computation of the allocable surplus, and into this they would be making the details of the bonus due to each of the employee, and the deduction has been made, and the annual return which has to be made by the employees. So this is their duty, and annual return has to be filed to the inspector, and that has to be before the 1st of February every year. So we are having the inspector here under section 27. So appropriate government may appoint such person as the inspector for the purpose of this act. The government, they can define the limits and the jurisdiction. So for the inspector, they would be doing the work into that particular area or into that region which has been allocated to the inspector. And when we talk about, so the inspector is having the right, because he can enter into any of the premises if the inspector want to see the record, and if need the register and he want to see the other relevant document relating with this, is having any kind of the suspicion, can see that. So the inspector can examine the employer or his agent or the servant, and so that is up to the satisfaction of the inspector, and he can make the copies of the if the inspector wants to take the material along with him, so he can extract the book from the employer, he can take the register or the other relevant document which has been maintained into that particular into that establishment. And assistant to inspector, any person required to produce any account, books, register or the other documents or give information by the inspector shall be legally bound to do so. So penalty can be imposed in section 28 if any person who contravenes any of the provision of this act or any rule made thereunder, or whom a direction is given or a requisition is made under this act, fails to comply with the direction or the requisition, he shall be punishable with a imprisonment for a term which can extend to 6 months, or with a fine which can extend to 1000 rupees, or it with both, if the offences has been done by the company in section 29. So for this, the director of the company or other responsible persons, because the company is a legal entity, so can be held liable for that matter. The officer or the in charges of the company, director, manager, secretary or the other officers, they would be held guilty for this kind of the offences. And when we talk about the cognizance of the offence, in section 30, no court shall take a cognizance of any offence punishable under this act. So the only that is the government would be making the appointment, so not below the rank of a regional labour commissioner in that case of an officer of the central government, and not below the rank of a labour commissioner in case of the officer of a state government, and they would be authorized. No court inferior to that of the presidency magistrate or magistrate of the first class shall try the offences punishable under this act. And we are having the special provisions which has been with respect to the payment of the bonus linked with the production of the productivity, and we have all the schedules has been given here under this act. So for the better understanding, they can, you can refer it. So this is from my side, and this was regarding the payment of Bonus Act 1965. So you can refer this. Thank you so much.